kind introduction. And thanks to all of you for coming. I thought what I would do is take about 40 minutes and teach a class just like I would if we were together and we were enrolled in constitutional law. And then take about 20 minutes and you can ask me anything you want about the class, why I would teach it this way, anything about law school if you want. And Chelsea's here to help me with any questions you might have about the admissions process. When I teach very much in a structure. I'm teaching federal courts this semester, an upper level class. Next semester, I'll be teaching constitutional law. When I walked into class this morning, I said to my students, we're under unit 3, we're under subunit C, we're at point 3. So everyone knows exactly where we are. I decided to take a case from constitutional law that I'll be covering next semester with the students. And what I would say to you at the beginning of class is that we're under, say it's unit 4, about separation of powers. We're under subunit A, about presidential power. And the first point I would begin with is the question, when, if at all, may the president exercise inherent authority? And this is an enormously important question. And so I actually spend a couple of days on it in constitutional law, not just the 40 minutes we have today. What I mean by inherent authority is when may the president act without express constitutional or statutory authority? If there's a specific constitutional provision that gives the president power, then the question would be, is a particular act within that authority? An example, the Constitution says the president can issue pardons. If the president wants to issue a pardon, we would then focus on, is the action within the scope of that power? If there's a statute, we could talk about, is the president's action within the scope of the statute? Might be a question of whether the statute's constitutional, but that's not what I'm talking about today. What I'm focusing on is, imagine a situation where there's not a constitutional provision, where there's not a statutory provision. When, if at all, can the president act then? This has been historically enormously important. It remains significant to this day. Let me give you examples. May the president fire cabinet officials? The Constitution says the president can appoint the cabinet with the advice and consent of the Senate, but it says nothing about whether the president can fire cabinet officials. That was the issue that led to the impeachment of Andrew Johnson in the late 1860s. Or another example, may the president invoke executive privilege? The Constitution says nothing about executive privilege. There's no statute about it. This was important when Richard Nixon tried to keep the Watergate tape secret, but it's important now in terms of, can Donald Trump invoke executive privilege with regard to documents concerning January 6th? May the president rescind a treaty? The Constitution tells us how treaties are made, but it doesn't say if the president can rescind a treaty. I can go on and on with examples of this, and I use them to show why this topic is so crucial. It's a topic that's been debated since the earliest days of American history. Early in the presidency of George Washington, there was a war between England and France. And George Washington decided he wanted to have the United States be neutral, and he wanted to issue a neutrality proclamation. He thought, wisely in hindsight, that the United States as a fledgling nation had nothing to gain by getting involved in the fight between these two superpowers. And he wanted to know, could he issue a neutrality proclamation? There's nothing in the Constitution about issuing neutrality proclamations. There's nothing in any statute. And none other than Alexander Hamilton and James Madison weighed in on this. Alexander Hamilton wrote an op-ed. He titled the name of the author, he wrote under a pseudonym Pacificus, and he said, the president can exercise inherent powers. He said, Article 1 of the Constitution says that Congress gets the powers herein granted, whereas the president doesn't have that limit in the Constitution. In Article 2, it doesn't say the president's limited powers herein granted. None other than James Madison disagreed. Madison wrote an op-ed under the pseudonym Helvidius, and he said the president doesn't have inherent powers. The president can act only if the Constitution or statute says so. That the purpose of the Constitution was to get away from royal prerogatives. When you take constitutional law, you'll discuss in great depth the debate over whether or not the meaning of the Constitution is limited to what was intended when it was written, whether we should be originalists. One of the problems is what happens when the foremost originalists, Hamilton and Madison, the authors of the Federalist Papers, disagree. And even though Hamilton had a play in his honor and Madison didn't, Madison is no less a luminary when it comes to the founding of the Constitution. What might surprise you, and what you would see over the couple of days in my class, is there is to this day no settled answer to the question of when may the president act without constitutional or statutory authority. And what I'd want you to see is that over varying points in American history, the Supreme Court has given 4 different answers to the question. And what I want you to see is that if you were a lawyer litigating it now, you'd pick the answer that's best for your side and defend it and oppose the others and vice versa. The single most important case on this question was Youngstown Sheet and Tube versus Sawyer. And I had made it available. I now understand some of you were able to get it and some not. Don't worry if you didn't get it. But if you did, you got to see that the Supreme Court dealt with this crucial question: when may the president act without constitutional and statutory authority, in a very high profile context. For those of you who didn't get to see the case, it's from 1952. Let me tell you a little bit about it. And then I want to have a discussion with you, just like what I do in class. This was during the Korean War, and there was a wage stabilization board that tried to make sure that wages increased, but not too much, not so much there'd be inflation. And it recommended an increase in wages for steel workers. The steel companies all made clear they weren't going to go along with this recommendation. They weren't going to increase the salaries for steel workers. So it seemed imminent that the steel workers were going to go out on strike. Steel is obviously crucial for so much of what goes on in war. And President Truman was worried that if the steel workers went on strike and there wasn't steel, it would greatly hamper the war effort. So President Truman asked his Secretary of Commerce, Eugene Sawyer, to seize the steel mills and have the federal government, through the Department of Commerce, operate the steel mills to make sure there was a continued supply of steel. Youngstown Sheet and Tube is one of these steel companies, and it sues, and it says that what the president is doing is unconstitutional. They sue the Secretary of Commerce Sawyer, who had seized the steel mills. And the question is, did the president have the inherent authority to do this? There was no statute saying he could do it. There's no constitutional provision saying he could do it. Could he do it? And the Supreme Court, in a 6-3 decision, ruled against President Truman and said he couldn't seize the steel mills, making clear that there's a limit on presidential power, even in wartime. But what I find interesting about the case, and what I do with my students and I'll do with you, is show you that there's actually 4 different answers found in Youngstown to the question of when can the president act without constitutional and statutory authority. And these are the same answers that you find in other cases throughout American history. So let me start with the majority opinion written by Justice Hugo Black. And if you had a chance to get the handout, it's the page 276, right at the beginning. And this was just Xeroxed out of the casebook that I use with my students. If any of you had the chance to read the case, why does Justice Black say that what the president did was unconstitutional? And if I teach a class, I rely on volunteers. I've never cold called on a student. I've never in any class relied on anyone other than volunteers. And thankfully, Students do volunteer and we do get discussion. So if any of you read the case, could you tell me why for Justice Black this is unconstitutional? Please, Gabriel.
Hello. Justice Black wrote in his opinion that President Truman taking this action amounted to a legislative action. And he said that the only legislative action that the president can take is to sign or veto laws that the legislative branch has already taken. So he said that this was not a power that the president had.
And for Justice Black, when may the president act if there's no constitutional or statutory provision?
Never.
Never. And I think that's Justice Black's answer. Alice, were you going to say the same thing?
Yes, I had the same answer.
So Justice Black would say the president can act only if there is a constitutional or statutory provision. If you have the handout, if you look on page 277 in the last full paragraph, the president's power of any to issue the order must stem either from an act of Congress or from the Constitution itself. There's no statute that expressly authorizes the president to take the possession of the property here. And then on 278, in the first paragraph, it says, it is clear if the president authority to issue the order must be found in some provision of the Constitution, does not claim that the express constitutional language grants this power to the president. I would call this model 1, and I'll set out 4 different models. In model 1, as Gabriel says, is there's no inherent presidential power. The president can act only if there's a constitutional or statutory provision. So if Richard Nixon or Donald Trump claims executive privilege, what would the answer be under this approach? They can't. There's no such thing because it's not in the Constitution or a statute. If a president wants to refuse to spend money, impound funds appropriated by Congress, can the president do that under Model 1 since there's no constitutional or statutory provision? No. Justice Black would say, President, you can act only if you can point to something in the Constitution or statute. And what I would do then, and I would ask you briefly, if you were a lawyer and you wanted to take this position, how would you defend it? What do you see as the benefit of this provision, this approach to answering the question, when can the president exercise inherent powers? Wait a moment and see if anybody else wants to jump in. And how would you defend this, giving the president no inherent powers? Gabriel, go ahead.
Well, it's a very clear guideline. No one can have any misconceptions about it. And also, it does align with a very, very strict reading of the Constitution.
Okay, so it has the benefit of clarity, and you'd say it seems consistent with the text of the Constitution. And I think James Madison would say it's consistent with the framers who were rejecting the idea of royal prerogatives, rejecting the idea of broad executive power. And if you were to criticize this approach, if you were to say that Black was wrong, well, how might you do that? And even if you didn't get the chance to read the case in anticipation of this class, now that you've heard what Black's approach is and what the defense is, how might you criticize it? What's wrong with it? Please, and is it Shang Yang? Am I pronouncing it right?
Yeah, you can call me Vic, but thanks for letting me. So
and how would
I
you
think,
criticize?
yeah, I think, well, first in the context of the Korean War, I think, the lack of a broader power of the presidential, like the executive branch, could lead to, could hinder the war effort. And that was, I think, also after the FDR's, reformations. So a very strict and narrow construction, interpretation of the Constitution and the power of the executive could have prevented, say, the establishment of the FCC and SEC, the new agencies that actually, combine the power of, that's defined in Article 1, Article 2, and Article 3 of the Constitution. So I think Justice Black's interpretation is a little too formal and not functional and pragmatic enough to address the new problems.
Excellent. And what you presented is the traditional criticism. It's too inflexible, that the president needs inherent powers at times, such as to make sure we win the war. And that it needs to be, to use your word, more practical than this. Now, if we had time in a regular class, I would have a longer discussion of the benefits and drawbacks, because that's what you'd write in your brief if you're defending or opposing the model. But let me go to a second approach. And here I want to focus on Justice Douglas's approach. And if you have the reading, it's pages 280 and 281. And I'll ask you the same question. Why, for Justice Douglas, was the seizure of the steel mills unconstitutional? His reasoning is different than Justice Black's. How so? And again, as somebody who had the chance to read this could answer, and I don't know how many of you got the reading in advance. You didn't. Lillian, did you get it?
Hello, yes.
Okay, well, how would Justice Douglas answer the question? Thank you.
Yeah, so with Justice Douglas, he specifically referred to highlighting the separation of powers. He insists on a review of the Constitution, specifically on the power of seizure that's attributed to Congress.
And why does the president's seizure of the steel mills for Justice Douglas usurp Congress's powers? What's wrong with it from Douglas's perspective?
He is basically just saying that because it was like not a temporary seizure.
Yes, you're absolutely right. He says Congress here is taking, the president here is taking private property. The president is taking this private steel mill. Under the Constitution, if the government takes private property, it has to pay just compensation. He said the president here is forcing Congress to spend money. He says, but Congress alone gets to decide whether to spend money. Congress has the power of the purse. You see this if you have the handout on page 281 in the second full paragraph. The legislative nature of the action taken by the president seems to be clear. When the president takes over an industrial plant to settle a labor controversy, it is condemning property. The seizure of the plant is a taking in the constitutional sense. A permanent taking would amount to the nationalization of the industry. A temporary taking, as Lillian says, what's here, falls short of the goal. But although the seizure is only for a week or a month, the condemnation is complete, and the United States must pay compensation for the temporary possession. The president has no power to raise revenue. That power is in Congress by Article 1, Section 8. The president might seize and the Congress might subsequently ratify the seizure. But until and unless Congress acted, no condemnation would be lawful. The branch of government has the power to pay compensation for a seizure, is the only one able to authorize a seizure or make lawful one the president affected. So as Lillian says, what bothers Douglas is the president here is usurping Congress's power to choose whether to spend money. By seizing the steel mills, that's a taking of property. There has to be just compensation. The president is forcing the United States government to spend money. And he says, the president can't do that. So what I would tell my students in class is this is model 2. The president has inherent powers until and unless the president usurps the powers of another branch of government or prevents it from being able to carry out its functions. Justice Douglas would say, there is some inherent power of the president. But the inherent power has to stop if the president is taking over the powers of another branch of government or preventing another branch of government from exercising its authority. I mentioned the example of executive privilege. Even though it's not mentioned in the Constitution, the Supreme Court has said the president has executive privilege. He can keep documents or conversation with advisors secret unless the president, by doing that, is usurping the powers of another branch of government or keeping it from carrying out its functions. So in United States versus Nixon in 1974, the Supreme Court said Richard Nixon is president of executive privilege, but he couldn't keep the courts moving evidence that they needed to write fair trials for criminal defendants. So then my question to you, and you can answer this even if you haven't had the chance to read the case. What do you think is the advantage of the second approach compared to the first? Or the disadvantage? If you're a lawyer and writing a brief and you want to take the second approach, that the president has inherent powers, until and unless the president usurps and interferes with the powers of another branch of government, how would you defend it? How would you criticize it? And of course, I always remind my students when I ask a question like that, they're all supposed to raise their hands and participate and offer suggestions. I remember a lot of reading. Is it Aman? Do I have that right? You're on mute.
You're still muted, Iman.
Yes, sorry. I would say that it strikes a bit of a middle ground. It retains some of the clarity of Model 1, but it also allows the government or the president to have some discretion when necessary, as long as it doesn't usurp the power of other branches.
That's terrific. So it offers more flexibility than Model 1, giving some inherent powers, but still having constraints, keeping the president from usurping the powers of another branch of government. And that's the traditional defense here of it. Sahar?
Hi. I had a question as I was
Anything.
thinking about that, because I realized that if Congress holds the purse strings, it's really, really difficult to not do any action that doesn't require some budget behind it. So in effect, the president has very little in the way of implicit powers because everything he could ever possibly want to do would require paying somebody else to do it.
So that would be a criticism of this approach. This would say this doesn't give the president enough power, because if the president can't do anything that requires spending of money until Congress is appropriated, that's too little presidential power. And of course, I was going to ask in a moment, what are the criticisms of this? And one of the criticisms would be just yours. This is too constraining of the president, just like some said Model 1 was too constraining of the president. Other arguments on either side? You've heard a good argument in favor and a good argument against. Do you see other arguments? Dominique?
One of the criticisms that, Douglas actually pointed out was that the president can move faster than Congress can. So in a state of emergency, if you're held up by those purse strings, you do need to be able to have that flexibility to move at a faster speed than just waiting for Congress to agree on something.
We need the president to be able to act sometimes in an emergency. And so you might say, compared to Model 1, this is much better because it gives some inherent power. But you might say, as was just suggested, perhaps this doesn't go far enough in giving the president power. What I'd want you to see is how much the choice of the legal rule affects what arguments are relevant in a court. That if you take the first approach, the only arguments that are relevant are, is there a constitutional or statutory provision? But if you take the second approach, then the arguments that are relevant is about, well, is the president usurping the powers of another branch of government or interfering with the powers of another branch of government? And I'd want you to use this to see how much the legal rule determines which arguments are relevant that you can make as lawyers. If we were in class together and we had more than the short time today, we'd have a longer discussion of plus and minuses. But let me move to another set of opinions. And let me here look at Justice Frankfurter's opinion. Justice Frankfurter's opinion is in your handout if you look on page 281 in the middle of the page. And why for Justice Frankfurter was Truman's seizure of the steel mill unconstitutional? I think it's a quite different answer than Justice Black gives or Justice Douglas gives, even though they come to the same result. Why for Frankfurter was this unconstitutional? For any of you who had a chance to read it. Gabriel.
Justice Frankfurter said that in his view, the legislative branch had not given up the power to seize private property without a formal declaration of war. He said that if he believed that they had not used that power or were fine with the president taking it, then in that case, President Truman's actions would have been permissible, but they hadn't done that here.
Okay, and so he's focusing on what Congress has or hasn't done. And Sheng Yang, I didn't hear what you said you preferred to be called, so I just see what's on the screen. But do you agree with
Yeah,
Gabriel?
no worries.
I'm sorry?
Yeah, no worries at all.
Okay. Tell me what you were going to say in terms of Justice Douglas.
No, I think Justice Douglas, like he pointedly stated that Congress has expressed its will to withhold this power from the president as though it had said so in so many words. So I think Frankfurter is pointing out that, you know, this power has been expressively stated, negated from the president. So, and in that case, that the president could not contend that it has any authorization at all.
Frankfurter says exactly that, and it's much like what Gabriel was saying a moment ago. Frankfurter says Congress considered giving the president the power to seize industry, and Congress decided explicitly not to do that. So Congress has rejected giving this to the president. If you happen to have the handout on page 281, the last full paragraph on the page, the question before the court comes in this setting. Congress has frequently, at least 16 times since 1916, specifically provided for executive seizure, etc. In every case, it is qualified the granted power with limitations and safeguards. The power to seize will be uniformly given only a limited period of time or for a defined emergency, was repealed after a short period. And then at the very bottom of the page, it says Congress in 1947 considered whether to give the power to the president, and Congress decided not to. So Frankfurter says on 282 in the first paragraph, nothing can be plainer than that Congress made a conscious choice of policy in a field full of perplexity and peculiarly within legislative responsibility for choice. So notice Frankfurter is not focusing on whether there's a constitutional or statutory provision. He's not focusing on, is this usurping the spending power? He says Congress considered giving this power to the president and decided not to do it. Justice Jackson, which has actually become the most famous opinion from Youngstown, says the same thing. I think Jackson is one of the best writers among any of the Supreme Court justices in history. I'd say he and Justice Louis Brandeis were the best just at writing. And Jackson says on 278, in the last full paragraph, we can't answer this question by figuring out what did the framers of the Constitution want. He says in the middle of that paragraph, just what our forefathers did envision or would have envisioned had they foreseen modern conditions must be divined from materials almost as enigmatic as the dreams Joseph was called upon to interpret for Pharaoh. A century and a half of partisan debate and scholarly speculation yields no net results, but only supplies more or less apt quotations from respected sources on each side of any question. And Jackson then says, there's different categories of situations. And the place where the president's power is at the least, he says, and this is on 279, is where the president is acting contrary to the will of Congress. And he says, here, Congress considered giving the president this power and decided not to. And you find this in the middle of 279. So how would Frankfurter and Jackson answer the question, when may the president act without express constitutional or statutory authority? I would define this as Model 3. The president can act without express constitutional or statutory authority until unless Congress limits the president's power. The president has inherent power until Congress steps in some way and stops the president. For Frankfurter and Jackson, Congress sufficiently acted by considering giving the president authority and not doing so. Now, under this third approach, the question is, has Congress disapproved of the president's action? And we can argue about whether Congress's failure to give power should be seen as disapproval. Under the second approach, we're asking, has the president usurped or prevented another branch of government carrying out its powers? Under the first, we're asking, is there a constitutional or statutory provision? But this third approach asks, has Congress in some way disapproved what the president has done? And so the focus is the president can act without constitutional or statutory authority unless Congress has disapproved it. And so if we were in class together, I'd say to you, what do you see as the advantages of this third approach? And what do you see as disadvantages of this third approach? And again, even if you haven't had time to do the reading, you can certainly see how this is different than 1 and 2. Jude?
Hi, I was just wondering, isn't the disapproval by Congress also sort of a statutory limitation on the presidential powers? And therefore, wouldn't it be just the same as saying that the president has inherent powers until a certain statute says that he doesn't? So I guess that's one of the limitations.
Sure. And of course, here, Congress didn't pass a statute saying, President, you can't seize the steel mills. What Frankfurter and Jackson find is the congressional disapproval is that Congress considered giving the president the authority, but didn't do so. Alice, you were going to say?
Yeah, I think another disadvantage is that at the time that the Congress was considering it, there may have been a lot of factors that ended up not getting it not passed, but it doesn't necessarily say that the Congress feels one way or another. So it's hard to know what Congress thinks, even
Great
now
point.
in the past.
There may be many reasons why Congress didn't pass this. It doesn't necessarily mean that Congress meant to disapprove this. It may be that Congress ran out of time or there were more important things or anything else. Other advantages that you see about this approach compared to 1 and 2, what disadvantages you see to this approach? Go ahead, Anna.
A possible disadvantage could be that Congress, like the makeup of it, changes so much based on party politics. So like what was once disapproval could easily change the next election.
Excellent point. It could change. Also, if Congress is willing to go along, then the president can do virtually anything. There's no limit on inherent power. So when you were talking about political party, I was thinking, if Congress is of the same political party as the president and unwilling to check the president, then the president has almost seemingly unlimited inherent powers unless the president's violating something in the Constitution. And do we want to have that kind of increase in presidential powers just because Congress hasn't acted? It's a very powerful criticism. On the other hand, if somebody was wanted to defend this third approach compared to the others, how might you defend it? I mean, Anna presents a great criticism. Alice presented a great criticism. How would you defend it? Go ahead, Elizabeth.
I would just say that it's inherently Congress's job to check the president. And so if we get into this question of, oh, well, Congress changes day to day, yes, but if Congress isn't the one to check the president, then who is going to be? Who can act swiftly enough to check a power in a case like this? And so, I think it's dangerous to assume that Congress didn't disapprove, right? We can infer as much from their not acting as we can from their action.
Terrific point. And the argument that's made is that Congress is the appropriate body to check the president. If you think about it, the difference between Model 2 and Model 3 is Model 2 puts the primary responsibility on checking the president on the courts. If the president is usurping the powers of another branch of government, interfering with the powers of another branch of government, the court should step in. Model 3 puts the primary responsibility for checking the president on Congress. And the argument is that in a democratic society, we should put that responsibility on an elected branch rather than an unelected branch. It should be for Congress to do this. And that's the argument that would be made in favor of Model 3. And again, if we were together in class and we weren't trying to compress this into a short time, we'd have a much longer discussion. But let me go on to the final model. And it's found in the dissent. The dissenting opinion is on page 283. And what I would do if we had time was present it as Model 4, that in certain zones, the president has inherent power that can't be limited by Congress or the courts. That there are some zones where the president, by virtue of being president, has inherent powers, and it can't be limited by Congress or the courts. And the dissent certainly expresses that in part, though in part it might take a Model 3 approach, but it's one that presidents have claimed. As examples, President George W. Bush claimed the right to engage in warrantless wiretapping and electronic surveillance, even though it violated a federal statute in the Constitution. Because he said, I as president have the inherent power to do this. This is a zone that's left to me. President Truman claimed in this case the inherent power to seize the steel mills. And presidents say there are certain areas where the president alone gets the power, even though it's not specified in the Constitution, even though it's not a statute. It's inherent power. And it can't be limited by the courts and Congress in this zone. And I'll just ask you quickly, if you were defending a president and you were defending a Model 4 approach, say President Bush, that he could engage in wiretapping, even though it violates a federal statute, how would you do that? Or if you were to criticize this, how would you do that? Anybody? Please go ahead, Chen Yang.
Well, I think drastic time, requires drastic measures, right? So if I were President George W. Bush, I mean, right after the 9/11 attack, to prevent further attacks, I think the president needs to be someone, I would like to use the word in Justice Vinson's argument, more than a messenger boy to Congress. I can't just go to the Congress every time I need to do something. And I think the fact that there is no statute prohibiting the president to do so, and there is, quite a national emergency that demands such action, some have justified the action. I think it's a pretty valid point.
I think you will have a job in the future as counsel to a president, because the president would love you being his or her advocate. That's what the president say, just what you did, that the president needs to be able to act in an emergency. This is a war. It's to protect national security. He's not violating the Constitution. He's not violating a statute. He should be able to exercise inherent power. And of course, those on the other side would say such inherent power is incompatible with the Constitution, that the framers meant to reject it, that we should reject it in a democratic society. What I would want you to see over the course of class, but I hope you can see even in our short time together, is there is no single answer to this question. And if we were together, I would show you other cases that take a Model 1 approach, other cases take a Model 2 approach, other cases take a Model 3 approach, other cases that take a Model 4 approach. The Supreme Court has never definitively chosen one of these. I'd want you to see how much in this area and all areas, the choice of the legal rule determines what's relevant as an argument. If a court's going to take Model 1, the only things that matter are, is there a constitutional or statutory provision? If they take Model 2, the only question is the president usurping or interfering with the powers of another branch of government? If you take model 3, you're asking, has Congress usurped, has Congress acted to limit what the president can do? In model 4, you're asking, is this one of those zones where the president can act and Congress can't limit it? And then we talk about the cases that have followed from each of these 4 zones and talk about what it means for you as lawyers if you have to argue a case in an area like this. And it's typical more than atypical, where there isn't a settled answer, but a number of possible answers. So this gives you a compressed sense of how I would teach this. But other than it being faster and less developed, it's very much how I teach constitutional law. And it's what I want you to see by going through this. But I'd also really want to emphasize how much for contemporary disputes. Could President Bush authorize torture in violation of the statutes and treaties? Can President Trump claim executive privilege? And so many other things. It really comes down to these 4 models. So with that, let me use our remaining time together now. You can ask me anything you want about Youngstown and inherent power, or about why I teach the way I do, or about Berkeley law, or anything else you want to ask.
And I'll just introduce myself real quickly. I'm Whitney Mello. I'm Erwin's assistant. We've worked together for the last 4+ years. And if you have a question, but you don't want to ask it yourself, you can send it to the chat to me in the chat privately, and I'm happy to ask it out loud. I won't identify you. Or just raise your hand and I'll call on you and you can ask Erwin yourself. Okay, Alice, go ahead.
Yes, thank you so much, Professor Chemerinsky. I wonder, you briefly mentioned, do we want to give a little bit of power to the judicial branch versus the legislative branch? I'm wondering your thoughts on the judicial branch right now, in the direction that it's going, and how much public trust there is in that branch of government, and whether, in our lifetimes, it will operate very differently in terms of a co-equal branch of government.
It's a great question. The Supreme Court approval ratings are at an all-time low. There's a Gallup poll at the end of September that showed 40% approval of the Supreme Court and 53% disapproval. And then there were a number of other studies, opinion polls in October that came to the same conclusion. What none of us can know at this moment is, what will be the effect of that on the Supreme Court? Is it transitory and the court's legitimacy will bounce back? Or is it long-term? To what extent is it about the court, or is it reflecting larger distrust and dissatisfaction in government? The president's approval ratings are at about that level right now. And Congress's approval ratings are much lower. I think the last I saw Congress approval ratings about 18. I wasn't sure if that was 18 people or 18%. What does it mean to have such low legitimacy and approval for all of the branches of government? And I worry about what it means, not just for the courts, but for the survival of democracy in that way. And I don't have any answer, but I think you raise a great question.
Sahar.
Thank you, Whitney, and thank you, Professor Chemerinsky. I had a question for you, sort of on your own personal philosophy. What do you hope that your students take from your classes and from Berkeley Law?
Above all, I want my classes in Berkeley Law to prepare you to be terrific lawyers. And so everything that I'm doing in class is designed towards giving you skills that you'll use as lawyers, as well as knowledge that you'll use. I mean, what we did today has an important underlying lesson about the relationship between legal rule and argument. And it carries over across not just constitutional law, but all areas of law. I'm asking you all the time in just our short time together, or in a whole semester classes, how do you argue this and how do you argue that? Because that's what I want you to be prepared to do as lawyers. That's what you do is argue. So I want my class, I want law school to train you to be great lawyers. I want you to be ethical lawyers with a strong social conscience. I want you to really care about what are the effects of what you're doing. I worry sometimes that law school teaches you too much to contemplate and doesn't focus enough on having you care. And I want you to be thinking always of what are the human consequences of the legal doctrines. I'm still teaching federal courts, and I'm teaching the material on habeas corpus right now. And the rules that the Supreme Court has made, I want the students to see, well, almost all habeas petitions are filed by pro se litigants. And the rules are so complicated that less than 5% of habeas petitions are granted. And I want the students to be thinking about the human consequences of that. So that's a short answer. I want law school to be as intellectually exciting and as enjoyable for you as it can be. I want you to, at the end, when you go to commencement, if you come next year, you'll be the class of 2025. And I want to come to your commencement in May 2025, and I want you to say that law school is a really exciting, enjoyable, among the 3 best years of your life.
Gabriel.
First of all, thank you, Professor and Whitney, for both of your time. I was wondering, Professor, what you thought. It feels like the fundamental question from this case is still pretty unsettled. Even though we got a decision from this case, we probably use the threefold approach more often than even the actual ruling. I was wondering if you think that the fact it's still so unsettled is a result of maybe the court's reluctance to try to settle it, even though there is a discrepancy in the courts. If you think that it's just an issue that you don't get good vehicles for that often, why do you think after so many years at this point, we're still debating what the answer would be to this case today?
It's a great question. I think there's an inherent tension between wanting the president to have the inherent powers to deal with emergencies versus, on the other hand, being very afraid of inherent powers in a democracy. And the court deals with this in specific situations. And of course, I had time in 40 minutes to consider one of these situations, but you'll look at the others, and I think you see that the Supreme Court decisions are so much a reaction to the particular context of the case. And so in United States versus Nixon, the court takes the Model 2 approach. When it came to whether the president can rescind treaties in Goldwater versus Carter, they take the Model 3 approach. We're going to, if you were in class, we were talking about, could President Trump issue the ban on immigration in the United States, keeping people from certain designated countries from coming in? And I think the court there took a Model 4 approach. And I think the results in the case so reflect the context. And the court has these different approaches to choose among. But you're right, it's strange that we're in 2021 for a document written in 1787. And maybe if nothing else you learn from coming today, there is no settled answer to the question, when can the president act without constitutional or statutory authority?
Andrew.
Thank you.
Thank you so much, Dean Chemerinsky. I had a quick question about judicial activism generally, and I was wondering if you could describe how the Roberts Court with its current composition stands with deference to lower courts or the other 2 branches, and how that might be different from previous courts and what reasons that might be.
I've often thought that judicial activism is just a label that people use for the decisions they don't like. And if liberals don't like what conservatives are doing, they call it judicial activism. If conservatives don't like what liberals are doing, they call it judicial activism. If I were to come up with a more principled definition, I would say a court is restrained if it's following precedent, an activist if it's overruling precedent. A court is restrained if it's deferring to the other branches of government, and it's more active if it's overruling the other branches of government. I would say it's restrained if it's ruling narrowly, and it's activist if it's ruling broadly. Now, that's not talking about what's good or bad. It's not normative, it's just being descriptive. By this definition, Brown versus Board of Education, that I regard as the epitome of what the Supreme Court should be doing, was very activist. It overruled precedent, Plessy versus Ferguson. It struck down laws that existed in every Southern state. It was broadly written, but it was necessary. So activism isn't necessarily a bad thing. I think the Roberts Court is quite activist in the sense of overruling precedent. Take Citizens United versus Federal Election Commission that overruled a 7-year-old decision and held that corporations to spend unlimited amounts of money in election campaigns. It struck down a federal statute, the McCain-Feingold Bipartisan Campaign Finance Reform Act. And it ruled very broadly that corporations can spend unlimited amounts of money in election campaigns. I can give other examples as well. Now, if we had more time together, what I'd want to say is both liberals and conservatives want to be activists in certain circumstances, and they want to be restrained in certain circumstances. They disagree when. I'll give a quick example, though I want to get to other questions. On Tuesday, June 25th, 2013, the Supreme Court in Shelby County versus Holder declared unconstitutional key provisions of the Voting Rights Act. It was 5-4 with the 5 conservatives in the majority, Roberts writing, and Justice Ginsburg wrote the dissent for the 4 liberals, urging deference to Congress. It's probably one of Justice Ginsburg's most famous opinions from her years on the court. The next day, Wednesday, June 26th, the Supreme Court in United States versus Windsor struck down a key provision of the Federal Defense of Marriage Act that said for purpose of federal law, marriage between a man and a woman. It was the 4 liberal justices in Kennedy striking it down, and the 4 conservative justices saying, we need to be restrained and defer to Congress. So on Tuesday, the conservatives are striking down the law and the liberals are saying judicial restraint. And on Wednesday, the liberals are striking down a federal law and the conservatives are saying judicial restraint, which leads me to believe both liberals and conservatives at times want activism and at times they want restraint. They just disagree as to when.
Thank you very much.
Lillian.
Yes, hello.
Hi.
So I actually just wanted to share, for my honors thesis, I cited a lot of your research on the studies that you did on the effectiveness of desegregation efforts in public schools. My thesis was more about the court's role on these efforts and whether or not it perpetuated the inequality of educational opportunity. It's actually a big part of why I want to go to law school in the first place. And I was thinking, where do you see the literature here going? And do you think the Supreme Court might approach the issue of equity, of educational equity again?
Wow. As you know, in 1973 in San Antonio Board of Education versus Rodriguez, the Supreme Court said the disparities of school funding within a metropolitan area don't violate equal protection of the Constitution. I think that's one of the worst Supreme Court decisions in my lifetime because so much is institutionalized, separate, unequal schools. I was part of a lawsuit that involved a challenge to the Detroit schools and claimed that there's a right to literacy and that the Detroit school system was violating that. And my side won in the United States Court of Appeals for the Sixth Circuit, and then the case settled. And I think that when the lawsuit was filed, the hope was that Hillary Clinton was going to become elected president. She was going to pick Supreme Court justices, and there'd be a court that'd be receptive to creating a constitutional right to literacy. I'm pessimistic that this court will do that. In terms of the literature, there's some great new literature that's come out. Jesse Rothstein, who's a professor at the Goldman School of Public Policy, he's just written a couple of articles that really document that expenditures on schooling do translate into differences in educational outputs. Because there is, if you know the literature, a debate about does spending more money necessarily mean better educational outputs? And Jesse Rothstein's articles, I think, from a very sophisticated methodological perspective, show that. So I think we're going to see more literature, in answer to your question, about the relationship between, say, spending or desegregation in educational outputs. But I don't know that we have a Supreme Court that's going to be at all receptive to that. That's a short answer to a really important question.
Thank you.
All right, Sheng Yang.
Well, first of all, thank you, Dean Chemerinsky, and thank you, Wendy, for hosting this session. So I have a question, with regard to Berkeley law in general. So Dean Chemerinsky, you mentioned that now the Supreme Court's public approval rating is at all-time low, and the composition is quite conservative despite having an executive branch that's liberal. So I really like your book on free speech on campus. And I know that Berkeley is quite, and your debate with the former dean of Yale Law, Robert C. Post, on the very same matter. So I'm wondering what efforts Berkeley Law has perhaps advanced in promoting open discourse and fair and balanced debates on issues such as, say, racial disparities and affirmative actions on the campus. Because I think now the low approval rating really demands us to understand the viewpoint from the other side of the aisle.
Since you're very kind and mentioned my book, I am deeply committed that a law school and that a college campus be a place where all ideas and views can be expressed. As dean, I look for opportunities to reinforce that and to further it. And so we have a vibrant Federalist Society chapter here, and we have a vibrant American Constitution Society. We have people who tend to bring in quite conservative speakers. John Yoo is the head of Whitney, what's the name of the thing that he and Brad Barber do?
Public Law and Policy.
Thank you.
You're
and
welcome.
They tend to bring in Janice Rogers Brown, formerly from the California Supreme Court and the DC Circuit, who's quite conservative as part of that. And on the other hand, we certainly have people who bring in liberal speakers, and we do programs where we have them have interchange. We did a program on last term of the Supreme Court and this term of the Supreme Court, where it was a couple of liberal professors, I'm trying to remember who they were, and a couple of conservative professors, and we disagreed. We agreed on some things. I think the more opportunities there are to have both sides expressed, and also to model civil discourse, that we've got to be able to disagree in this society without being disagreeable. That again is a short answer to a long question, but it's important that we as a university be a place where all ideas and views can be expressed.
And I don't see any more hands, which is perfect because it is 5 o'clock. So Erwin, I don't know if you want to wrap things up to say goodnight.
Sure. You're welcome to come sit in on classes in the spring. I know Chelsea and Kristen will work that out. You're always welcome to come sit in on my class, and I'm sure at my colleagues' classes, they'll work all of that out with you if you happen to be in Berkeley. If you ever have questions about Berkeley law or about law school, you're welcome to email me. My email is easy to find. Whitney put it in the chat, but I'm also the only Chemerinsky on the Berkeley Law website, so it's pretty easy to find it in that way. And I wish you each all the best in the application process to law school, choosing a law school, and I hope you'll come to Berkeley Law. But wherever you go, I just wish you all the best as law students in your career. And let me know if I can ever be of help to you.
Thanks so much.
Thank you.
Thank you both. It was great.
Thank you
so much.